Great. So the way this is going to go is we're going to call up each person who submitted an idea and have them present their idea for 3 minutes. We've distributed the ideas amongst us four, and so we'll be grilling the contestant on their great idea, and then we'll open it up to the floor for other questions, comments, and then we will have a round of applause to see where the person ranks on our applausometer. And at the end of the session, we will select the 3 out of the 5 that we consider with our scientific method did the best, in order to do another round of applause and see who the grand winner is. So without further ado, over to Cynthia for your contestant. You need a mic.
May we have Dana McGrath come, please?
Like a game show.
Yeah, absolutely. Big prizes.
Okay, just
Yes, take it
3
away,
minutes. Okay, my idea is to have the procedural timetable in an arbitration be a freestanding, independent procedural order. And the reason for that is because it has been my experience that the timetable or schedule changes, and you want to ensure that when adjustments are made, they are fair to both parties. And if you have a freestanding procedural order that memorializes how the schedule changes, you can both track the fairness and how the schedule changes, and also ensure that when you are writing your award, you have easy access to the procedural timetable that is important for the procedural history, and it saves a lot of time. And it's also good for the parties to be able to see how the schedule has changed, particularly where the parties differ. If one party seeks a 6-week extension and the other party resists and says no more than 3 weeks, and how did the tribunal come out? You know, I think it's helpful to show transparently, you know, what extensions were granted by the tribunal so that you can see the procedural fairness. And I think there was one other aspect of my proposal, and that is that every procedural timetable that I prepare, if possible, includes a window for settlement discussions or mediation. This is in a traditional arbitration, maybe less so in an expedited arbitration. And the thinking there is that parties are reluctant to open settlement discussions because they don't want to be perceived to be showing weakness. So I think every schedule, if possible, should have that at an important inflection point, maybe after the main memorials come in, the evidences come in, and the parties and the clients have a more realistic understanding of the strength of their case. And that window should not interrupt the schedule, but should be concurrent with the overall timetable of the arbitration. Thank you.
Right on time.
Oh, Dana, hang on. We have some questions for you.
Stay
You're
up
not out
here.
of the
You're
hot
not done.
seat yet.
I don't know the game show rules. Okay.
So can you start by telling us a little bit about yourself? So where are you located? How long have you been an arbitrator? What types of disputes do you typically arbitrate? That kind of thing, just some background.
Okay. I am from New York, born and raised, and I am practicing in New York. I have been in commercial arbitration for my entire career, which is several decades. I don't like to age myself, but I was in big law, so to speak, for about 20 years. I spent a few years in third-party funding, focusing on arbitration funding, and then I went full-time independent as an arbitrator in the middle of 2021. While I was in private practice and in funding, I had a few arbitrations concurrently as arbitrator while I was acting as counsel. And since 2021, I've been doing it full-time, and I focus on commercial arbitration, although I've done some treaty work in the past as counsel and looked at many treaty cases in the context of arbitration funding.
Okay, fantastic. Thank you so much. In terms of the procedural timetable that you mentioned, how long have you been using that kind of procedural timetable, separate procedural timetable, as part of your practice, and what was the genesis for it?
I have used it since I went full-time as an independent arbitrator in 2021. I never really thought about doing anything otherwise. I know that it's often suggested that the timetable be appended to procedural order number 1 or 2 or whatever number you want to give it. I always made it a separate procedural order and give it a number. Let's call it procedural order number 3. And when it is amended, I update it to make it procedural order 3A, 3B. We've even gotten up to like 3K, depending on the case. And that makes it easier for the tribunal and the parties to see how it has evolved and to reach it easily for drafting the award.
Okay, and you talked a little bit about including negotiation or settlement discussions as part of that procedural timetable. And you told us a little bit about the thinking behind that. Do you typically include only one window for those types of discussions or multiple?
I typically include one, although I've discussed with tribunal members in certain cases proposing 2, particularly if there's a multi-phased arbitration. Usually we settle on 1, but sometimes there are 2.
And is that something that would be within the purview of the tribunal? Would you be involved in those negotiations or mediations, or do you prefer to have it done by someone else?
I have nothing to do with it. The tribunal has nothing to do with it. We make that clear when we introduce the concept of putting that in the procedural timetable. We don't want to hear anything about the negotiations or mediation. If it's an administered arbitration, we'll remind them that that institution may have resources should they want to mediate and tap those resources. But the tribunal and I, as a sole arbitrator, really don't want anything to do with that unless there's a reason for the arbitration to be suspended and then to be notified of a jointly requested suspension or stay of the arbitration for the parties to continue negotiations, but none of the substance, and I don't do ARB, Med, ARB, or any of those things, at least today.
Thank you. I think we have a few minutes if there are any questions from the audience that might help you decide who to clap loudest for at the end of the day. Any questions?
Dana, at the end of this settlement window, do you ask them to report, yes, we have tried to settle and nothing's happened, or if there has been a partial settlement, would you expect them to come back and say, we managed to settle issue number 3?
I don't ask about the settlement negotiations, not in the context of the window or otherwise. I do find that sometimes I'll be notified by the parties jointly of settlement discussions that actually happen outside of the window. So I tend to think that maybe having a window just puts that idea in their head, but I don't ask.
All right, great. Thank you very much, Dana. Over to you.
Now I can.
Oh, yeah, sorry. Over to the applause. Absolutely. Right? Thank you.
Okay, is Lorraine Ducqua in the room? Thanks, Lorraine. Please introduce yourself, your practice to the room, and your best idea.
Okay. Hi, everybody. My name is Lorraine Dakwa. I'm from Ghana. I'm starting my PhD with Josh at Queen's in September. I'm a lawyer, arbitration practitioner, and lecturer. My pitch It's called the Mini Arbiter Initiative. So how many of us have gotten asked this question? How do I become an arbitration practitioner? Is there a definite course one can take to become a chartered arbitrator? When did you get your first appointment as counsel or arbitrator? Can I see by hands? If any of us have had those questions being asked by young, yeah, almost everybody in the room. So to answer these questions, I had an initial initiative, the arbitration pitch, where I interview, it's a YouTube series where I interview arbitration practitioners just to pay it forward and let young arbitration practitioners know what to do. Now, this mini arbiter initiative is a one-year mentorship program where a senior arbitration practitioner of at least 5 years sits on at least one case with a young arbitration practitioner of no more than 2 years of practical experience as an arbitration practitioner. So the mentor is 5 years and above, and the young arbiter is at least 2 years. The key stakeholders will be the arbitration practitioner who is above 5 years, the arbitration practitioner who is less than 2 years, and then arbitration institutions or organizations. Now, here are the advantages for each of the 3 key stakeholders. The senior arbitration practitioner, the successful completion of one case in a year, while mentoring one arbitration practitioner who is younger, will qualify this practitioner for 1 year subscription free membership. And talking to a lot of senior practitioners, that's a challenge because they want to be subscribed to more institutions, but the fees are just rising. Then for the young arbitration practitioner, at least they would have sat on one case, and then the arbitral organizations, they'll be able to pay it forward and say that they are contributing to the growth of arbitration across the globe. It'll be a great initiative to run as a collaborative effort between many arbitration organizations to ensure inclusivity and maximum benefit across the globe. Let's do this. Thank you.
All right. Well, thank you, Lorraine. I love the idea of some sort of program for mentorship and advancing the careers of young arbitrators, the next generation of arbitrators. But I want to dig into the details a little bit. In your proposal, who is actually the arbitrator that is appointed to decide the dispute? Is it the senior arbitrator while mentoring the junior arbitrator, or is it the junior arbitrator that is actually the decision maker and receiving some advice and mentorship from the senior arbitrator?
Okay, so this initiative is looking at ongoing arbitration. So you're attached to the arbitrator, not the dispute.
Okay.
So when you're attached to the arbitrator, the senior arbitrator, within that year, if they have any case that they can have you on with the consent of the parties, probably as an observer, or you can help as a tribunal secretary, whichever works for the mentor, but there should be some collaboration within that year. And once we're able to certify that there was one case, at least one case that was done with a party, with a younger arbitration practitioner involved, you qualify for that free membership for 1 year.
And so would parties have to opt into the involvement of the more junior arbitrator on their case as well?
Absolutely, and I think this will not be too difficult because we have mentees who join. I have been a mentee on several arbitrations, and the parties are usually not too objective to that.
Okay. And are there costs associated with this, or are the costs borne by the institution?
There are no costs associated with this because I will testify that there are lots of young arbitration practitioners who give anything to just sit on one case.
And in your experience, because it sounds like you've engaged in programs like this already, does this circumstance give rise to any unanticipated conflicts of interest or concerns related to conflicts of interest related to repeat appointments from the same young arbitrator or more senior arbitrator, given that you're involving more people on a variety of cases?
The issue of conflict usually arises when we have senior arbitration practitioners who have done multiple cases. But for a young arbitration practitioner who might be the first or second case, the issue of conflict might not arise.
Okay. Perhaps we can open the floor to my other panelists or the audience for any questions.
How do you suggest vetting the young practitioner, or would that be done by the institution?
Okay, so I'm looking
How,
at this.
how are you suggesting vetting, just for the audience?
Okay, so I'm looking at this mini arbitrator initiative as a standalone initiative, just like I kept thinking about greener arbitrations. It's not an organization standing alone, it's collaborating with a lot of different organizations. So they'll have their own administrator who does the vetting to ensure that the party qualifies to either be a senior arbitration practitioner who can mentor the young practitioner, or a young practitioner who would involve themselves in the mentorship program. Thank you.
All right. Oh, one more in the back there, yeah.
How do you get the parties to agree to have the person participating in the arbitration?
We inform the party. So, as I mentioned earlier, I've been on a number of these before. I've not been in a situation where the parties have declined. You inform them that this is someone who is on the case as a mentor, and the parties usually do not decline such.
Would you restrict this to only lawyers who are trying to get their first arbitration, or would this be available to other practitioners who want to also be arbitrators who have a difficult time getting those introductions and opportunities?
All persons who are moving in the arbitration trajectory should be allowed to join.
Over there, Paul.
So, I like the idea a lot, personally, as a non-lawyer arbitrator, I like it. But at the Canada branch of the Chartered Institute, we tried to introduce something like that, and we found, unfortunately, that the parties resisted because of the influence that the junior arbitrator could have on the final decision. We were also trying to do it for pro bono work as well, and unfortunately the program just never really got off the ground. In principle, I think it's wonderful. In practice, I think it runs up against the potential for conflicts, and it's much more difficult to implement. So,
Brief reply.
cold water on it.
Yeah, well, brief reply.
Yeah, so
To
just
save your
briefly-
idea.
Yes, so just briefly, I'll say that the young arbiter is not going to contribute to the final decision or anything of that sort. It will be made clear that the person is just an observer. And I've been in such arbitrations where I was made just an observer to observe how the arbitration process moves along, to know what it entails.
Thank you, Lorraine. Perhaps we can.
Well, I think in fairness, I should counter the last
Go-
comment.
Okay,
Go
fair
ahead,
enough.
fair enough.
Go ahead.
And just say that I have done this a number of times, usually at the initiative of someone who wants to sit in on the arbitration. I have never had a party refuse. And I think generally speaking, it's always been a very positive experience for the mentee, and I think that to some extent for the mentor as well.
Thank you.
Thank you. Perhaps we can put up the applausometer.
Thank you.
All right. Thank you so much, Lorraine.
All right. So now over to Emily McMurtry, please, for your best idea. Sorry? So yeah, start with a brief introduction and then go for your idea.
You got it. Well, good afternoon, everyone. Are we still in the morning hour? No, we've hit the afternoon. So
Yep.
thank you for having me. I'll spend a brief 3 minutes telling you what I'm not sure if it's the best idea. That'll be up to you to decide, but it's certainly an idea that's been brewing in my mind for quite some time. So I'm Emily McMurtry. I'm a senior associate with Denton's in Ottawa. I also sit as an arbitrator for the Fruit and Vegetable Dispute Resolution Corporation, and that's in large part the source of where this idea comes from. So, establishing a small claims roster comprised of junior arbitrators. And those cases would be dealt with certainly in an expedited fashion, perhaps documents only where it's appropriate, and the tribunal's fees would be fixed at a value that's commensurate with the amount in dispute. I think the upshot here is twofold. First,
We give commercial parties the opportunity to access expedited and hopefully confidential arbitration dispute resolution procedures for smaller value claims. I know in my experience, I have certain large corporate clients who might have a claim for $60,000. They don't want their dirty laundry exposed in the courts. They don't want to wait 2 years to have a hearing. And this is something that could be very attractive to them in terms of access to justice. But the second part would be to also provide a credible and clear pathway for those at the early stages of their arbitration career to secure their first appointment. And that is certainly the way that I was able to secure my first appointment, was by being on a roster with the DRC. And I did that in 2022. So at that point in time, I was only in my 3rd year of practice. And it felt very counterintuitive to most people in the community that I spoke with to say, you know, this is what I'm up to in my 3rd year of practice. But realistically, there's no reason why junior arbitrators can't deal with, you know, a contractual interpretation dispute, an unpaid invoice dispute. And it gives them that avenue to build their competency and build credibility in the arbitration market very early on. So that is my idea. I'm sure there's probably, you know, some practical issues that come with it, but I think an institution, Adric, I'm looking at you, could probably set something along these lines up. It would dovetail nicely with the simplified rules, and you know, perhaps have some qualifications in terms of requiring these juniors to satisfy maybe the QARB course or the CIARB course, something to establish themselves before being appointed to that roster. So that's the idea.
Great, thank you. So how do we determine what would fit within the small claims? What's the threshold that we're looking at?
And I think that's tough. I think that's a number that is, it's growing every day. I think I spoke with someone from out west who said that the small claims, maybe in Alberta, I'm not sure, that it was increasing up above $100,000. In my mind, I was thinking, you know, $100,000 and lower, but I think that would ultimately be up to the institution to decide, you know, here's the collection of cases that we are seeing, and the types of cases that come here, this is what kind of fits in that lower threshold. So I don't know, my mind was 150,000 or less. And I think that would be something that would be attractive to commercial parties who really don't want to wait for the courts to go through their motions.
All right, and would it be mandatory that this process, if you're under 100 or 150, you go through and you have junior arbitrators that are necessarily assigned, or it's an option?
No, I don't think it needs to be mandatory. And again, I think that would be something that would have to be up to whichever institution, or maybe it's its own body that picks this up to decide, you know, here's the threshold and this is the way it's going to work. But I think if you're talking about a fixed fee model, it's probably something that parties would simply want to opt into, where they think it's appropriate and where that fixed fee would make sense for the dispute at hand.
All right, and what is a junior arbitrator?
You know, a tough question, right? I mean, I think the times are changing in terms of the profile that we see in Canada for the junior arbitrator. And I think there was probably a time, even when I was very fresh in my practice, where a junior arbitrator was someone with 20 years of practice. I think for cases like this, and we're dealing with small claims, again, contractual disputes, maybe invoice disputes. I'm not really envisioning the complex disputes, but I guess if the value is low enough, it might fit in that box. But I would say we'd want to be targeting junior practitioners at the earliest stages of their careers. So I'd say certainly fewer than 10 years.
Fewer than 10 years. And you actually hit on one point that I had in my mind, that it's not because it's lower value that it's not complex.
Yeah,
so what do you do with that?
That's a great point, and that's an experience that I've run into in the context of my work with the DRC, where you know you have a low value claim. It might be worth $15,000, but you also have two parties appearing before the tribunal who do not have the benefit of counsel. So you know the arbitrator is actually put in what might be a bit more of a procedurally challenging dispute to address, but ultimately, I think there's got to be boundaries for us to assess when this could apply, and perhaps if it's not something that's mandatory based on threshold, right, then you know the parties have the opportunity to decide, you know, this is a simple enough case, let's refer it to a junior on the roster.
Great. All right, over to the audience. Any questions on this idea? We have a few hands up. Great. If we could get the mics on the right here, please. Marianne, over here. Yeah. Please, thank you.
I think it's a great idea. I have a little bit of experience of this when I was a JD student, and then after I graduated doing pro bono work. There's some facilities set up in New York where arbitrators and mediators sort of sit on the side in small claims court. And when a case is announced, the judge says, well, I can put you down for trial in 3 months, or you can go talk to the arbitrator or mediator right now. And then there's a Harvard law professor, I've forgotten his name now, came up with the title of a multi-door courthouse. It's been implemented in a number of places, I think probably most expensively in Nigeria. And the idea is that sort of collaboration between courts and ADR practitioners. That can work well. My question is, can you make this work without the active collaboration of the court system?
I mean, maybe now's the time as the rules are getting their overhaul for this idea to pitch its way in that direction. But I think so, Josh. I think it's a matter of the institution picking up on something, or any institution picking up on this idea and implementing it. And if it's available, you know, I'd assume parties would want to use it. It would be something certainly in my practice where if a client came to me with, you know, a lower value dispute that appeared to be relatively simple, or maybe perhaps, let's say, not overly complex, that's something that I wouldn't be afraid to recommend. And perhaps that's because I have had the pleasure of encountering and dealing with a lot of young arbitral practitioners who are so competent. So I think it's something that we might initially be afraid of, but I don't think we should be. And I think with the right, you know, institutional support, I think that's necessary for something like this, but I think it doesn't necessarily have to be the courts for it to work.
Great. There was another hand over here. Yeah.
Sure. Just picking up on what you just said, talking about institutional support, I wonder if you've considered whether having institutional review of the decisions prior to their being issued, the pros and the cons of that.
Yeah, I think that's a great idea. I know myself, there's a review provision in the context of the DRC's rules, and it's certainly not something that's interventionist. It's very akin to perhaps what you'd expect from the ICC, but it's something that gave me comfort, certainly in my first arbitral award, knowing that there was going to be someone else having their eyes on it to make sure all the T's were crossed and the I's were dotted. So I think that would be a great addition to something like this, Mary.
Great. One last question. I think Louise had her hand up. Yeah. That was it? Okay, so then quickly, in the back there, sure.
How is this different from the expedited rosters with various institutions?
Mm-hmm.
And also, how is it different from the next gen roster at Arbitration Place?
I think it's different because in my mind, you know, speaking, you know, if I go back into my mind bank from about 2, 3, 4 years ago, for example, and I open up the next gen roster and I see the names on that roster, you know, relatively in the community, they're junior arbitrators. But as a junior arbitration practitioner, you see these people's resumes, their bios, their 10 years, 15 years of experience, and in your mind, you don't think that's a junior arbitrator. So hopefully that answers the question without putting an age number
Right.
on boundary on things. Yeah. You are young. Yeah, yes, you are the young ones. And I'm telling you, I was thinking of both of you when I was like,
All right.
next gen roster, you know, that's some pretty impressive profiles. So yeah, you hit the nail on the head.
So time to vote, because I don't want to give too much time to my candidate. So applausometer.
Thank you.
Over to you.
All right. So I would like to call Barry Leon. Is Barry here?
Yeah, he's right in the back. Making his way.
And before you get to the stage, let me start by saying how grateful I am to be here, to be invited to this panel. I came from São Paulo, Brazil, and it's been great. Great day yesterday, a lot of good ideas. Thank you so much. Barry, you have 3 minutes.
Well, let me use a few of my seconds to say how great it is to have you here and to have your support for this. It's really wonderful. And I think this is worthy of applause, too, just for their support. Now, I don't need my full 3 minutes because it was subcontracted to Dana McGrath, mediation windows, and Dana actually gave a pitch for it, unprompted. I did not bribe her to go back to the corruption session. She, on her own, supported my idea, which is to have a mediation window. And you heard from her, so I won't repeat what she had to say. What I would add to it is that if you're going to build into the timetable a mediation window, it needs to be done in a way that will work for the parties, and it may actually need to be a floating window. That is, it may not be able to be determined right at the beginning, because it may be that the timetable has to have some flexibility in it so that the mediation can take place at the appropriate time. But the point of the mediation window is that often, as in any dispute process, whether it's arbitration or litigation, counsel gets so focused on, as they should be, on preparing the case and the strategy of the case, the witnesses, the documents, the evidence, that they don't have the time to take a breather and focus on mediation or settlement. And so the idea is to build it in so that they have the time locked in, and they can know that there will be an opportunity, whether it's at a fixed time or a time to be determined, where they'll have some period of time, a breather, to focus on settling the case. And maybe it's more than one. Maybe you build in a couple of mediation windows. You can do that if you can have some flexibility in the floating dates, all working towards the fixed hearing date. It needs to be done in a way that the parties know that it's not, they don't lose the opportunity to settle or to mediate if they don't use that window. So if the mediation window happens at a stage when the preparation is partway along, you also want them to know that it's not a drop-dead process, that if they don't use it then, they can never use it. But it deals with this problem, which frequently occurs, that people just don't have the time. There was an idea suggested many years ago by Roger Fisher, who wrote Getting to Yes, which was to have a settlement team along with the litigating or arbitrating team. And that is somebody who would just be focused on settling the case. And some corporate counsel or others will do that. But this is another way to ensure that the case just doesn't rush forward on its own momentum going downhill towards the hearing, and nobody ever gets the time to deal with mediation. So that is the idea. I'm glad to have Dana's warm-up act for it and her support. And you can take her reading on the applausometer and add it to mine, and that will be the total.
No, let's try to make you win, because there is only going to be one winner, so let's try to make you win. And let me ask you something. Is it, your idea is meant to be something that parties agree with the arbitral tribunal or with the arbitrator after the dispute already started, or is something that you can add in the arbitration agreement?
I wasn't thinking of having it in the arbitration agreement, but we do have arbitration clauses which have step clauses, which we're all familiar with. There probably isn't any reason why you couldn't have an arbitration clause that says the parties, if they can't settle through direct discussions or can't settle through mediation, will go to arbitration. And in the course of the arbitration, the timetable shall provide another opportunity to mediate. I mean, you could have that in there, and it doesn't, I don't think, cause any other problems. But I was thinking of something that would be done at the first procedural conference when you're setting the timetable.
Okay, and one more thing. When I read your question, my first reaction was to think about how institutions should deal with it. And I may say, in Brazil, we are not used to ad hoc arbitration. We almost never see it. So there are always institutional rules applying. CAMS-CBC, for example, has a provision that if you do first mediation and you don't settle and you start arbitration, the costs of the mediation will be considered and deducted from the costs of the arbitral proceeding. And if you do it in the middle as a window, half of the costs will be deducted. So it's a way to incentivize parties to mediate.
That's the institution's cost.
Institution's cost, yeah, not the mediator's costs. So in your reality, I know that you have a lot of ad hoc arbitrations and also institutional arbitrations. How does these costs would fit in your idea of a mediation window?
Well, absent some agreement, which would be the institutional rules, and I think I think you are probably ahead of a lot of institutions in having it built into your rules in that way. A lot of institutions don't, or I think the AAA ICDR has it built into their rule press. All of the institutions encourage mediation in one way or another these days, or most of them do. But in ad hoc, I think you just build it into your procedural timetable, and the parties could agree, but because there's no institutional fees, you couldn't do what you're doing of having it deducted, but you could have some other way. It may make it too complicated. I think the main thought behind my idea, and it's not my idea, I'm just repeating ideas that I've stolen from others, is to just make sure there's time to do it. And if there is an institution, I think one of the values that institutions bring to it, and certainly your institution does, is to encourage the process to take out the thing that we all know exists, which is no one party wants to say, or usually doesn't want to say, let's mediate, because they think it's a sign of weakness, which it isn't. So if the institution is doing it, or if it's built into the timetable or built into the mediation clause, you don't have that problem. I don't know what ADRIC has done in its new rules, whether it's built in anything, but I probably shouldn't give Mike any of my time. But everything's possible. Everything's possible.
So over to the audience. Are there any questions for Barry? Yeah, Bill?
Point of information, yes, ADRIC rules do encourage the parties and the tribunal to incorporate a mediation window. My question, Barry, is you have one aspect is the floating window, and I'm just curious about how that works, and in particular, who triggers or fixes, if it's a floating window, then I'm assuming you're not fixing it at the outset, then how does it get triggered? Do both parties have to agree to trigger it? Can any one party trigger it, or does the tribunal trigger it? How does it get triggered and stop floating?
Yeah, as long as it doesn't sink, you're okay. I mean, what it would be, and when I call it floating, it's really that the parties may not appreciate it in the tribunal, at the front end of the arbitration, when you're setting the timetable, when is the right time to do it. So what you'd say is, if you've got a year-long timetable, and you know you want to have I'm just making these times a 1-month period for mediation, all the other steps would take the 11 months, and you might not fix when that 1 month comes in until you get past the, say, disclosure of document stage. And it would be fixed either by agreement of the parties, and the timetable would then just float out, or it would be fixed if the parties can't agree. But if the parties can't agree, it's kind of a silly way to start the mediation, where the tribunal is ordering them when to mediate. But that would be the idea, is really to make it at a time when the parties feel it's most appropriate, but they would know they've got this 1 month in their 12 months, and the other 11 months are taken up with the other activities. And I came up with this idea just because it was suggested to me that during the earlier break that this kind of idea has caused problems where the parties think that they are locked into mediating at a time that's not going to work for them. So this is a late breaking addition to my idea.
All right, it's time to vote.
Remember, I get all of Dana's votes.
All right, and for our last contestant, if I could get Anthony Davis to come up on stage, please. Is Anthony there? Yes. Welcome, Anthony. It's me. It's me. You have 3 minutes.
3
so.
minutes. Well, I may not. Given my talk or my pledge, I shouldn't use all 3 minutes, because my idea is what I call the efficiency pledge. Persuade by using sentences that say less but mean more. The whole idea is to try to have presumptive page limits, time limits to arbitration, and to actually implement them. And arbitrators who adopt this efficiency pledge can set themselves apart from maybe arbitrators who don't necessarily adopt it. The idea here is really just to encourage brevity. After all, anyone can write a 50-page brief, but it takes real skill to write a winning 15-page brief. That's kind of the big idea, and I guess it came to me from a few cases where after reading multiple pages, I didn't really know why I was reading so many pages, because the point should have been made in the first 5 pages. In fact, my view is if you can't tell me your argument in your first 5 pages, you don't know your argument. And so this should encourage, I would say, efficient, effective, and experienced lawyers should really love this, because they can show that they understand what actually matters. So this efficiency pledge also has some nice synergy. We have heard Barry Leon yesterday talk about the environmental pledge. Well, fewer pages, shorter submissions is good for the environment. We heard Bill's talk about making sure arbitration doesn't resemble the court system and how bloated the court system is. Well, efficient arbitrations support that view. So there's a lot of synergy going on in our group here. And that's why I've thought of a few slogans. Win in 10. 10 is a new 40. I don't know what you think about that. Quality and efficiency aren't trade-offs. They're teammates. Okay, you prefer the first one. Okay, so that's basically the idea that it's really very much going back to the ethos of arbitration. It has always been sold as a more efficient process. But some of the complaints that I've heard from both counsel and even arbitrators is that this efficient process doesn't seem so efficient. Well, maybe we should start doing something about it. Hence, my efficiency pledge.
Great, thank you.
Yeah.
What about less is more?
Yes. 3 words, always better than 5. Yeah.
There you go, excellent. So, I mean, lawyers like to talk and write and think, hopefully. But so if we sign up to this pledge, what does that mean in terms of word limits or time limits on hearings? What do you have in mind?
Yeah, so thinking is great. The idea is that you don't force your reader to watch the way you think as you write. Instead, you do your thinking first, and then when your thoughts are clear, you write them. And it's not, if you need more time, that's fine. Like anything else, you can justify why you need more time, but you should have a good justification for it. If you have a good reason why you need 25 pages to explain a simple breach of a term of a contract, well, tell me. I'd be very curious to why you need 25 pages, but maybe there's a good reason. So it's not a forced, you can only have 10, but it's the idea that we start with the presumption that you don't need so many pages and time.
And in your written submission to me, or to us, you mentioned that the pledge could lead to less anxiety and stress.
Yes.
How so?
Well, a lot of the times, and I see this also when I wear my other hat at the university, and which is why I've implemented word limits to answers to questions, because a student is given a question and they think, well, I guess I better just start writing and writing and writing. The more I write, the better it is. And then they might hear from one of their colleagues, oh, I only answered that question in 1 page. And now one of them has some anxiety because I hear that somebody else took 25 pages. And that does actually happen. So when you're actually forcing them into a certain limit, if they hit that limit, they don't feel like they've missed something or that they should have added more or should we keep going until the minute before the deadline. So that's another way. Also from arbitrators, and this is also more when I was an expert, what bothered me was, you know, as an arbitrator or an expert, you actually have to read the materials that are given to you, even if most of it is nonsense. So you get this anxiety of, well, how much am I supposed to read? Well, I better read it all. And then as an expert, when you're cross-examined, you don't put anything in front of your on the table, otherwise that gets to be put before the lawyer. So now you've got to try to remember everything there. So that's a lot of anxiety, especially when most of it is nonsense.
And actually, this ties into something that was said in one of the panels yesterday, that really you've got the 15 binders in arbitration, but really it's the 15 documents in that first binder that everyone's going to read and look at, and that ultimately will make a difference. So that's the efficiency.
Absolutely.
That's the pitch.
You're making the point. You're a great patron.
Or a little biased, maybe.
Oh.
All right, so over to the audience for questions, comments. Yes, right here in the middle. It's coming.
Does this limit also apply to the arbitrator's award?
I don't see why not. Again, if I'm receiving efficient submissions, there's no reason why my award can't also be efficient. Yeah, so that's a great point. Yeah.
Hi. First of all, I love this idea. I've been, as you know, in court in Ontario, I'm sure in other provinces too, we have 30-page, sometimes 25-page, double-spaced, 12-point font page limits. And when you move out of the court process, you're like, where am I going to use those skills of like cutting down, right? So that's really great. Some participants in arbitration processes, counsel, who bill by the hour, sometimes can be less, they're not incentivized sometimes to want efficiency, right? Unlike the clients who presumably are.
Yeah.
How do you convince them that it's good for them too and they should agree to this?
Well, I'll tell you what I've told some of my former students to say, if you're really good at what you do, you can feel fine about a higher hourly rate, because your higher hourly rate might look jarring at first, but if it only takes you 1 hour to do what most lawyers need 3 hours for, then actually your higher rate is a better rate overall. So that, I think, is how those who take the pledge can justify maybe a slightly higher hourly rate, and then you get more cases, so you're going to make your money. Exactly. And it really does. It takes more time to get your submissions down to what really matters. I agree completely, yeah.
Lots of hands. Barry, you have a mic, so might as well.
So just
remember, I supported your environmental pledge, right?
yes, it's a joint entry. Just picking up on that point, and this is just I think it's an arbitration I was on, but if not, it's a good story that somebody else told me. There was a page limit for the arbitrator. The decision had to be, I think it was a procedural issue, 5 pages. They get an email from the arbitrator saying, I've written 10 pages. Do you want to pay me to reduce it to 5 pages?
Over to Dana in the back. Mariam, Dana? Yeah.
I'm wondering if this is in part inspired by the use of AI to either shorten or elongate submissions.
No, that's I hadn't contemplated AI for this, but that could be a good use for what is a tool we all have to deal with. It's here, and if it can help us be even more efficient, why not? Yeah, as long as it's disclosed.
All right, last question.
But if it's voluntary, how are you going to, what happens when one person decides to take the pledge and the other party doesn't? I mean, once it's voluntary, instead of being enforced, the lawyers will figure out a way to get around it.
Yeah, well, I would think about it more from the perspective of it's the arbitrator who's taking the pledge. And I remember very early on in my career, one of our arbitrators that we had was, maybe some of you have heard of him, Carl Bockstiegel. And now he had something known as the Bockstiegel method. The first time I saw it, I was like, oh, this person is really controls everything, but it's because it was based on efficiency. And so anytime you were to appoint or get stuck with Bockstiegel, you knew what you were getting into, and that affected how counsel would deal with your arbitrator. So if it's the arbitrators who are taking the pledge, I don't think it would be a great idea for counsel to go against that idea of efficiency. That would be how I'd respond. So I don't know that counsel are free to take the pledge, certainly. But those arbitrators who do might actually find counsel prefer them.
Great, thank you very much.
Okay.
So, time for the vote when you're ready.
Thank you.
All right, we'll need 2 minutes for deliberations, and we'll be back with the top three, and then we'll do a vote, an applause vote for the top three. So we have the results of the top three, and we will ask you to do one more round of voting. Sorry? Yes, of course. All right, so I know. All right, well, there you go. These are our top three, Emily, Lorraine, and Anthony. So those are the top three, and amongst those, we will choose the winner. So we'll do another round of applause meter, starting with Emily's small claims roster. Great, thank you. Afterwards, Lorraine with the mini arbiter. And finally, with Anthony's efficiency pledge. And the grand winner is Emily McMurtry, who wins CanArbWeek 2026 free ticket. Woo! Well done. Yes, come take a bow. Voila, bravo. If you want to accept the award, 30 seconds or less, you can accept your award.
Thank you so much, everyone. And hopefully we can see some smaller value claims make their way through some efficient small claims rosters and get some next gen arbitrators up and running. Thank you.
Emily,
Thank you.
Emily, just 1 minute. You have just won a free tickets for São Paulo Arbitration Week for the CAMS-CBC Congress, October in São Paulo. I wait you there. I wait you all.
I will see you
but
there.
But you have to pay for the ticket.
What a
Emily
surprise gift.
goes for free.
Wonderful.
Thank you so much.